Well, welcome to Expand Your Practice. My name is Lori Coonan. I'm the Chief Learning Officer for the Heritage Institute. Today's webinar is all about beneficiary well-being trust planning and preparing that next generation for their inherited wealth. It's a huge focus right now due to the Delaware Trust Act of 2024, but what we've realized is that this is a developing trend, right? It's not just with the Delaware Trust, but also within the multi-generational family wealth planning space. So this session is being recorded today, and we'd like you to use the question and answer or the chat feature to share your questions. And then at the end, we will take time to get to those questions. So now I'm going to turn it over to Rod Zeeb to introduce our guest.
All right, so those of you who know we had the Mastering Multi-Generational Wealth Conference in October, as we were getting started with that, Jay Hughes introduced me to Jennifer because she had created and was working on and teaching a course at the University of Delaware for people who are going to be, make sure I get this right, going to be trustees, with the focus on being enhancement focused rather than just distribution focused. Well, from that, then when we had the conference and we talked about the act that came out, and that was Jay and I and Johnny Warnick, that legislation with the beneficiary well-being trust in it had a huge impact on the conference. And it's pretty obvious that once Delaware does it, all their other dynasty trust states are going to do it. And the thing is, it doesn't have to necessarily be in a dynasty trust anyway. There's lots of different ways you can use this. So as we're getting ready for the webinar, I contacted Jennifer, who then introduced me to Todd, who actually wrote the statute that we're going to be talking about. So that's where we got to there. So I'm now done. All I have to do is introduce these guys. We're going to talk about the Beneficiary Wellbeing Trust. And although it's in the context of the Delaware legislation, remember that the concepts can be used a lot of different ways in other multi-generational wealth planning. So with that, I'm done. Jennifer and Todd, I'm not sure who's going to start. So
I think I'm going to start.
Okay.
And Jennifer's going to operate slides. So
okay.
There may be a little I'll tug on my ear or something to give the cue. Yeah, so I'm going to start off and sort of frame the discussion first about how we're doing right now in terms of our typical trust drafting, planning, discussions with the clients, and trust administration, how that has an impact on beneficiary well-being, the kind of techniques that we're using, and maybe where some of those shortfalls are, and why we might want to start thinking about having discussions in a different way by proactively engaging with the clients around the subject of what is the beneficiary's lived experience with the trust, and how do we want to see the trust over time be used to enhance beneficiary well-being instead of what clients often sort of express as a fear that it's going to have a detrimental impact on their descendants. So if we could get to slide 3, we're going to just talk a little bit about the conventional drafting techniques that we've been using, and kind of why there might be a need to do something different. I mean, when I work with ultra high net worth clients, and that's a very big part of my practice, more and more the techniques that we use to put wealth into trusts for future generations in perpetuity, more and more those techniques have been so successful that these trusts can be incredibly large, life-changing amounts of wealth, because the exemptions are high, and we're using installment sales and grants and all these kinds of different things. And more and more I'm hearing from clients that their real big concern is, this sort of thing that's out there, this big sort of monster in the closet that people just sort of are vaguely aware of, that these, I'm going to ruin the lives of my children. They're going to be trust fund babies, and they're going to be lazy, and they're going to, end up on, drugs, and they're, it's just going to be a big, I'm going to ruin their lives with this money. And how do I avoid that? And so they express that fear. What I also see is that a lot of the attempts historically to place restrictions on distributions, caps, limits, meeting certain, value standards, or, if this happens, you don't get any money, and on these birthdays you get X amount, and that's all you can get, and it's capped. that those things are very limiting, and they also conflict with the flexibility you want with discretion to be able to do decantings and modifications to the trust, because invariably, and I'm on a call almost every week with a client when they do put those types of strictures on a trust structure, that ultimately then they are seeking to change that because situations change and they become outdated, and you can't really lock things down. So in my experience, I think that attempts to address beneficiary well-being in a trust usually come down to these two categories of either restrictions on distributions or restrictions on information. And we have silent trust statutes around the country, and in Delaware, it is ubiquitous. I mean, people at this point are doing silent trusts in almost, to some degree or another, in almost every single trust document, because they are fearful and concerned that getting information to the beneficiaries is going to ruin their lives. So let's just keep it a secret and let's not tell them. So now the trust is based on essentially deception, and keeping the beneficiaries in the dark and letting them go about their lives and make life choices until some age attainment, when there's a big reveal and they find out that everything they thought about their lives and what they were able to do and had accessible to them was all a lie. And actually there's a trust there that could have, informed different life choices, to fulfill their purpose in life, so there are a lot of downsides to that, which I could go, for an hour about silent trusts as well. What I've also found is that a lot of what many might consider boilerplate, a lot of the provisions in trust documents really have an impact on beneficiary well-being, often in unintended ways. And that if you don't discuss those with the grantor, and you're just talking about, tax savings and, growth of wealth and things like that, without addressing how the beneficiary's lived experience with this trust is going to be impacted by things like, will the trustee consider or not consider other sources of income or assets? If it says that they shall or that they may, which most corporate fiduciaries interpret as shall, because if we may, we ought to, because if we don't, we could be in trouble, so they just do, they'll ask beneficiaries for budgets, tax returns, receipts. And the experience of a beneficiary with a trustee, when they are being asked to jump through hoops to get distributions and to prove the need, and just sort of basically nobody feels comfortable disclosing their balance sheet, their financials, and their income to somebody sitting in an office in Delaware or what have you. That's a certain type of experience a beneficiary is going to have, as opposed to something as simple as having language that says you shall not inquire. It doesn't mean that you're not going to have a conversation with the beneficiary to assess the distribution need, but as a matter of policy, from the fiduciary's perspective, that's going to be a different administrative experience. And I've seen conflict develop that ultimately results in removing the trustee or litigation over these types of things. Precatory language is something that is often paired with discretion, but trustees don't really they don't feel like they're getting paid to take the time to get to know the beneficiaries in their lives and understand all of these things. So they steer away from that, or that language ends up just sort of languishing, and it doesn't get fully implemented in the way the grantor might have intended that it would. Discretionary versus HEMS, is it a support standard? Is it discretion with support? Do you want to provide a base level of maintenance and support for beneficiaries if there's enough wealth in the trust? These are conversations that I'm starting to have with clients in the planning phase, so that they understand what these choices are, based on my experience seeing litigation, seeing trust administration issues, seeing conflict over 2.5 decades of practice. You can use your experience with other clients and other controversies that come up to inform your planning beneficiaries on what they might be on the lookout for if they have this provision versus that. So that's kind of what I see as the state of affairs in these attempts to address beneficiary well-being. If we go to the next slide, I would just briefly mention that I think beneficiary well-being should be considered and addressed at all phases of both the conversation with the grantor of the trust as you're structuring the trust, to address what the beneficiary perspective is going to be as a beneficiary of the trust, to take that into consideration when you're drafting the trust, and then also from the fiduciary's perspective when administering the trust. So in that planning conversation that you're having with the client, my approach has shifted to addressing more about what is the client's why. As people that went to law school or, have an MBA and all these different, sort of areas of training that we have in planning, we are really experts on tax savings, how to grow assets and invest the assets, and how to protect the assets with that as a protection. And those are the sort of tools in our toolbox that we could readily pull out because we feel confident in those things. That's our training. And we could dazzle the clients and show our worth, and the fees that you're paying us are worth it because look at the money we're saving you and how we're protecting the assets and doing all of those things. It's a lot less comfortable to have a conversation with a client because it starts to creep in the area of feeling like you're practicing, armchair psychology, to start talking about, well, why is it that you're doing this? Is the client's primary motivation really just to, stuff the largest amount of money possible into a trust that's out of the reach of, the taxing authorities and creditors, and frankly, out of the reach of the beneficiaries? Or isn't the client's purpose, if you really got into that conversation with them, the real meaning behind this for them is to provide a resource that's going to provide for the well-being and success of their future generations, leave a legacy behind that carries forth the family values and legacy, and makes the lives easier of their beneficiaries, and doesn't make them feel like they're a subject of a legal regime that they have no control over. I have those conversations to talk about how this financial resource might impact the client's family. One of the ways I do that, and a way to make it easier, and here's a takeaway on the next slide, a takeaway perhaps that those of you in the planning community might want to really think about using. I realized if I'm going to say that I do this, I really need to walk the walk, and I should maybe leave a trail behind of the fact that I did this, and something that's helpful. Whenever you go into a doctor's office, if it's a new doctor, the first thing they do is have you sit in the office for 30 minutes and fill out a form that has this questionnaire with all of your health background. And if you do an annual wellness visit, they ask you questions about whether you're depressed and how you're sleeping and how many drinks you have every week and all that kind of stuff. And that gives the doctor, some information and background to help the doctor deliver appropriate care and understand the context and where you're coming from. What I did a while back is invest a little bit of time in preparing a trust planning guide for my clients. And what I did was took my form document, and it's got a lot of bells and whistles and optional language and different things like that. And I said, all right, let me explain all of this, all these options to the client with a glossary of terms, because we can't take for granted the fact that clients know what a power of appointment is, or who a trust protector is, and these things, what the options are. Do you want a directed trust or not, a silent trust, and things like that. And I also included questions that get the client thinking, not only about these choices, and they can fill it out if they want. Usually they don't fill it out and send it back, but at least it gets them thinking. But it gives me a drafting roadmap for it. And it also starts to lead the client towards thinking about the beneficiary well-being issues. So I'm going to give you some questions off of this slide that are literally directly from one of the first slides, pages on this planning guide that I've put together, that are designed really to have the client start to think about these things and orient around the beneficiary's experience, that when you get into the other questions about how you're going to structure this trust, they're already thinking about how that's going to impact the beneficiaries. So I do, have it in there where I say, what is your definition of success for your family? And can you describe that in non-monetary terms? Is success being a millionaire, or is success being sort of happy and well-adjusted and having a healthy lifestyle and having good family values and raising great kids, having your kids go to good schools? Describe your non-financial goals and objectives for the trust and the beneficiary's lived experience with the trust. What do you hope this wealth will help your family accomplish, and why? And what are your greatest fears about the impact of wealth on your children and grandchildren? And I've got a lot more questions than that around these subjects. I just pulled 4 of them out to give an example. But I think that when a client starts to think about those questions, they're going to start to think about, why they're doing this, and, whether really just locking these assets up and keeping it silent, not letting them know about it, versus shifting that paradigm around more about how you might hope that this wealth is ultimately going to help the family, accomplish their goals and enjoy well-being. So the next slide, I just want to make the obvious point that beneficiaries are people. And all people experience challenging life events, and they happen at various different stages of development in our lives. Childhood, reaching the age of 18, getting married, experiencing death in the family, illness, losing a job, on and on we can go. There's all these stages, and a lot of times people need support and resources to help develop skills to be able to cope with those things and to get more knowledge and awareness on what is possible in terms of them working through these transition stages in their lives. And inherited wealth itself, and the money that's in this trust that you're creating itself, can be a contributing factor to a positive or negative impact on these events in their lives, or it could be a mitigating factor, and it could help them. So what I'm going to pivot towards, as we're going to start talking about these beneficiary well-being trusts, is the concept that a beneficiary well-being trust can be a financial resource, or what I like to think of as a family bank, that actually is a resource to provide some programs and tools that can provide knowledge and skills for the beneficiaries of critical life stages throughout. It's not that the trust is solely, that's all the trust is for. It's a trust that has distribution standards and can make distributions and so forth. But it's also embedded within it that it's going to be able to be something to help beneficiaries, be well equipped, better equipped than the average person who doesn't have a trust fund, to be able to address these things. So next, I'll just make the point that there's a better alternative to restricting distributions and restricting information. If the trustee could retain and compensate service providers, and this is before I get into the statute, this is sort of, for me, where I kind of started to have an aha moment about a different way of doing it, instead of putting language in a document that says the trustee shall hire psychologists to provide, ensure positive psychology, or intervene and monitor whether the beneficiary is on drugs or something like that. What about, instead of pinning all those things down up front in the document, we just set a trust that the trustee as a fiduciary is required. It says shall retain and compensate service providers, whether they are short-term university programs, counselors, life advisors, wealth management experts, lawyers that understand trust law, provide these programs and seminars and workshops and things at these different life stages, and that the trust fund could be the financial resource to cover the expenses of that for the beneficiary. So within the sort of bundle of rights of a beneficiary as a beneficiary, their interest in the trust as a beneficiary includes the right to be able to get these things as an expense in the administration of the trust, ideally, although that's something Jennifer's going to talk about in a little bit. Delaware in 2024, as Rod alluded to, adopted really two new statutes. One is the new Beneficiary Wellbeing Statute, which is found Section 3345, Title 12 of the Delaware Code. And there's also another trustee power section that applies to all trusts whenever created. So it's not something where you have to create a special trust. Any Delaware trust that's ever existed, that's still in existence, now has a trustee that has an explicit trustee power to provide some sort of beneficiary well-being programs, and to the extent that it's appropriate within the terms of the document under distribution standards and what people's rights and interests are as a beneficiary. So getting into the detail of the beneficiary well-being statute, it's what I would call an opt-in statute, which means the document itself and the governing instrument would say 3345 applies. And interestingly, the statute, and this was intentional, it uses the word governing instrument, and in the Delaware Code, the word governing instrument is defined not only to include the new trust agreements that we're going to be creating in the future, but if you were to decant or do a non-judicial settlement agreement or have a court order or any other consent modification agreement, any of the other tools that we have under Delaware law that can alter or modify a trust agreement, you could have an existing trust through a decanting or a non-judicial settlement agreement that opts in and references 3345 and becomes a well-being trust. And so, if somebody's got a trust with $500 million out there and it's, really large, and the original grantor starts to have concerns about its impact on beneficiaries, might be something to consider. And it says that the rights and interests of the beneficiaries and the duty and authority of the trustee are as provided in the statute. And the statute says that the trustee shall provide the beneficiaries individually and as a group with beneficiary well-being programs. What are beneficiary well-being programs? They're, personal coaches, workshops, counselors, programs, short-term university programs, one-on-one meetings, counseling. You go out, you sit down, you bring somebody who's an expert on family dynamics. When there's a rift in the family or something like that, you sit down and you mediate things, you educate, all of that kind of stuff. And the purpose, there's two subcategories of purposes for the programs: either preparing the generation for, intergenerational wealth transfers and wealth management, estate planning and philanthropy and all of those things, or educating the beneficiaries about family history, family dynamics, family values, family governance, and well-being, which is included in that list. And so, hosting a family summit, having a family meeting, family retreat, things like that are all included in something like that. And the trust document under 3345E could provide for additional powers and duties and rights and interests. And so you can draft additional stuff, and then the statute's going to say then you shall do those as well. And it says that the expenses of this will be paid by the trustee as an expense of the trust to the extent permitted by law. So what does that mean? I mean, I guess there's an area where this could start to look more like a distribution than an administrative expense, depending on what it looks like. And I think Jennifer's going to talk a little bit about that. But I would say you're maxing out whatever the applicable trust law would provide for to allow for this to be an expense of the trust. And it's in addition to and without diminishing the level of trustee fees that the trustee is entitled to for doing the investments and the accounting and the tax returns and the distributions. So there's not an impediment for the trustee to want to provide these things, because the compensation, whether it's the trustee doing it, an affiliate of the trustee, or an external third party providing beneficiary well-being programs, they can all be compensated. So it could be the family's family office that's providing these services to the trust for the beneficiaries, and there could be a revenue stream that goes to the family office, or for the financial institution that has an affiliate or somebody somewhere in the organization that is the sort of family, next gen group or something like that. And they might be adding those as basically a, just an expense line and not a revenue generator for the financial institution. But now it's intentional. If somebody wants these things, you pay that group to do that. And it might be additional compensation for the financial institution, which is going to incentivize the trustee to actually provide these things, because we're trying to set up incentives for that. I'll just briefly talk about the well-being power. It's kind of a watered down version of all this, and it doesn't say you shall do it like the opt-in statute. It's more just that all trusts have a trustee that has the power to do it, but that whether you exercise that power or not, goes through the same type of lens as, whether you're exercising a power to borrow or lend or buy life insurance or whatever. The trustee decides whether or not to do it, but there's an explicit power. So the last thing I want to talk about quickly, let's see, go forward to slide 13, I think it is. Yeah, there we are. So this is something that, now this is, you all are the first to see this slide. This is the first, even though I've talked about this subject, this is the first time this is seeing the light of day. But I feel like the critical thing here is, how do we operationalize this so that trustees are interested in doing these, that the conversations are being had, and that they can be set up and they are actually administered, and it's successful, and we get this thing off the ground, and other jurisdictions might do this. What I decided to do, thinking about these stages of life, is down that left column, just talk about a bunch of life events, and I'll highlight a couple of these just to illustrate the example, and what kind of implications that might have as a beneficiary of a trust, and what kind of a well-being program a trustee might deploy at those stages. And maybe a trustee has something like this as a part of their sort of policy manual, for lack of a better word, of how you're administering a beneficiary well-being trust. And maybe, it's not going to be like a hard and fast rule that you have to do these things at these stages, but let's say beneficiary turns age 18. Without other language in the document, that means that beneficiary is going to start receiving trust account statements. So having a course or a workshop with that beneficiary where you schedule it, you go out, you sit down, and you say, here's how you read a trust account statement. There's an income column, there's a principal column, you see some debits, you see some credits. Nobody without any education on this stuff has any idea what any of that means. What's income? And people think capital gains are income, right? It's not when you have a trust. It's, income, it's interest and distribute dividends and rent and stuff like that. And when you get these statements, how do you interpret this? You're now, going off to college. You're capable of actually, your age of majority, you're capable of having your own estate plan now. Maybe we should talk to this person that they're in a really wealthy family about having a will at that point in time. I know some ultra high net worth families where they're talking to the kids about like their social media presence and how not to be susceptible to, a potential mate or being entrapped by somebody because they're after them for their money as they go off to college, right? There's a lot of really, these are important things that are kind of foreign to those of us who aren't in ultra high net worth families, but they're very important to them. And so having something that's a beneficiary well-being program to address that. What about the death of a measuring life? Okay, you're G3 and your parents are G2 and they're the main beneficiaries. And when they die, the trust divides per stirpes and you're going to get your own trust for you and your descendants. You've transitioned now to the next generation and you're going to probably be involved with the estate administration of your parents' estate. They might have to raise liquidity to pay estate taxes. You might need a family summit so everybody gets together and understands what happens next and what's the beneficiary impact now that you're the primary beneficiary of your own trust that's dividing because, mom or dad passed away. There might be a large distribution as an age attainment in the document, and you're going to get this windfall of $5 million because you're age 40 or something like that. I think a little course on wealth management and how to handle that money and not blow it all might be useful. Family disharmony, where you've got siblings that don't speak to each other and they're all in a pot trust. Maybe we have to start talking about dividing the trust. Maybe we need to have a little bit of a family meeting and a family summit about how to find, family harmony and what the family legacy was and how this is going to break the hearts of your grandparents if you're, not talking to each other. Different things like that. Retirement, substance abuse, having a terminal illness, getting a divorce, buying a house. These are all stages in that earlier slide where it showed like stages of life where you're a baby, you become an adult where you're standing upright, and then you're an old person, who needs to be cared for. These are all different things that happen through the lifespan of a beneficiary, and they present challenges, and we have a financial resource here if you have a beneficiary well-being trust to provide skills and tools and knowledge to be able to navigate successfully through those things. And I don't see how that could be a bad thing. So on that, I'll turn it over to Jennifer to talk about this, from the administration perspective.
Thanks, Todd. Nice to talk to everybody. And when I say thank you, Todd, what I really mean is thank you for codifying this. Thank you for teeing this up and giving trustees a roadmap for doing what they should be doing anyway. So a trustee, in my opinion, which is why years ago I started to teach the concepts and the philosophy of J. Hughes to enhance the beneficiary's life, that there is a duty to care for the beneficiary that's broader than just the duty of care, the duty of prudence. Trustees should want to provide for the well-being of the beneficiary. They take on the obligation to do so when they accept the trust and the trust appointment. In doing that, how do we actually translate this statute into trust administration to administer this type of trust and this type of language in a trust for the well-being of the trustee? How does this translate to the fiduciary? Because the drafter can opt in, the grantor can opt in, but the fiduciary cannot opt out. So if there's an opt-in and the fiduciary is now presented with this, knowing that the beneficiary has a certain set of rights associated with that trust and the administration and the carry through with the administration of that trust, how do we get from beneficiary rights to a place where Jay describes a beneficiary bill of rights? What can we expect? How can we get from A to B when well-being tends to be less common of a motivator for people who are settling trusts? Typically you find motivations, as Todd described, as tax minimization, asset protection motivation, protection for the beneficiaries against themselves, against their lack of maturity, lack of experience, lack of exposure. But we need to be able to translate this into an opportunity for meaningful relationships to be built between trustee and beneficiary. One of the things that I hear so often from trust administrators and trust officers and really just trust companies in general in my work through the university and engaging and liaising with different trust companies is that, we're all concerned about that retention, that stickiness with the relationship. And, when generation 3 comes up, that's not my trustee, that's my dad's or my grandfather's trustee. And the trust companies are looking to retain those younger generation beneficiaries that are coming up. And the way, this is the key, I think that this is the bridge to that. This is the gap filler, because it really invites the trustee to build that meaningful relationship with the beneficiary. It promotes, the purpose of this is to promote individual growth, development, and to utilize those trust assets to bolster that and provide for that growth and development. Often you hear beneficiaries talking about a feeling of dependency or parental sort of structure within the trust, and it's my money and I want my money and I'm not able to get my money, and there's these kind of rigid barriers between really developing an interdependency between trustee during administration and beneficiary as the relationship develops. We want to see this statute as it comes to life being a way to deliver agency for the beneficiaries, stewardship for the beneficiaries, so that they have a sense of almost ownership over the outcome of the use of those assets. Even though, they're not the owner, the trustee is the owner. It's the trustee's responsibility to encourage autonomy, encourage learning, encourage family values, encourage carrying that out when the trustee's job is to really live the purpose of the grantor as it pertains to those assets being distributed out to the beneficiaries. Todd had just mentioned, when he sits down and he talks with grantors prior to settling a trust, he really tries to delve into the why behind why you're doing it, which really, really speaks to me because I'm a massive Simon Sinek fan. Like when he came out with, Leaders Eat Last and What's Your Why, I was like, where have you been my whole entire life? I absolutely adore you. That's everything. But what does a trustee do? And what does a drafter do when the grantor says, well, my purpose is tax savings. That's my purpose. My purpose is not to convey, the well-being to my children. There are all kinds of people out there. That's all well and good, but when it gets down to the trustee's hands, the trustee still has the obligation, the fiduciary duty to act for the benefit of the trust beneficiary. We don't have an option as trustees to say, my primary goal is tax savings. It is a goal. It is one thing that we have to do. But if success looks like financially focused only, the trustee still has that obligation to provide well-being to the beneficiary. And this statute is really what bridges that gap and gives that trustee, who is a corporate trustee and risk adverse and trying to manage multiple beneficiaries, it gives them the bridge to get there. So let's take a look and break down what is well-being. Todd said beneficiaries are people too. I believe that everybody that's here and connected to the Institute already buys into that belief that they're people too, because they are. So what is well-being from a more abstract perspective? So extrapolate well-being from the trust itself, but it's an overall state of happiness, it's health, it's prosperity. It's a more holistic approach. And if trustees are able to, or feel like they've been given permission almost in the statute to actually engage with their beneficiaries so that they can facilitate in the administration, the enhancement of a beneficiary's life and administer for the beneficiary as opposed to distribute to the beneficiary, will be able to really understand what is the beneficiary's goal? What is the beneficiary's need? Get to know them, build the relationship, really try to step into the shoes of what do you need? Why do you need it? How can I help get you from A to B? How do we get to yes? How do we collaborate with the beneficiary to facilitate that they meet their goals, to facilitate the framework of providing education and supporting the beneficiary's goals? What did we know before we learned it? And the it being anything. We have to learn everything. We know nothing until we learn it. What do we know before we experience it? We know nothing until we experience it. We have no coping skills until we have an experience that drives the need for it. These things, the chart that Todd came up with all of these life experiences, they're no less stressful and they're no less valuable just because somebody has a pot of money or a pot of assets that are going to help that person. Just because you have wealth doesn't mean that you have financial literacy. In fact, the fact that you have wealth may discourage your knowledge of financial literacy. It doesn't change the fact that you have this, that you have life experiences that are very different lived experiences from many of the people that you engage with. There's a level of discomfort for a lot of beneficiaries in being able to find their place and know how to relate this wealth, this inheritance, in a way that's not uncomfortable for those that they are engaging with. So we want to try and use this statute to develop a sense of partnership toward progress between the trustee and the trust beneficiary. We want to substitute the trustee as the decision maker in a parental role, with the trustee being a decision maker or an agent for helping the beneficiary create decision-making skills, create coping skills, create value, not through judgment, not through bias, not through conditional support or the feeling of micromanaging. It's creating interdependence and not dependence. And this statute really provides the opportunity for us to drill down on that as trustees and to facilitate enhancing the beneficiary's life. So when I talk about enhancement and care, we provide for, not distribute to. Yes, we distribute to. That's very technical. It's very structured and rigid. And, yes, on a tax return, it's going to be considered a distribution if you do A. But how do we treat enhancement? So I thought about this a lot, and I really decided, how do I articulate enhancement and care? And what does this look like? So in my opinion, it's financial stability in a self-sustaining manner. You may have a pot of assets, but it may be fully discretionary and you can't get to those assets. And you have language in that trust that says, other resources have to be considered. You may consider them, and your corporate trustee is going to extrapolate that to a shall because they have a risk structure and a regulatory structure that they're operating within. And maybe the beneficiary doesn't even realize that. They don't know that. It would behoove the trustee to sit down with the beneficiary and say, this is actually what my job is. This is what a trustee does. This is why we do it. Enhancement and care is emotional and mental well-being. Trustees have to be given the ability to provide that to the beneficiary without the fear that they're going to be running afoul of some fiduciary duty when, quite literally, that is what they should be doing anyway. They have that fiduciary duty already built in. This just gives the technical validity to actually carrying out that individual growth, enhancement with self-sufficiency, fostering community engagement, family support, understanding family dynamics, being able to solve for family discourse, promoting well-being, both physical, mental, having healthy living resources, encouraging that self-reliance, and really giving the beneficiary the ability to feel like they have some control over outcomes in their life, because so many beneficiaries just feel like things are happening to them as opposed to happening with them or for them. And that's that shift from distribution to enhancement and care and benefit for the beneficiary, acting for the benefit of. So we want to inspire the beneficiary and give the trustee the ability to feel like they can do that. And now with this statute, we can, right? We have this ability now to write it into an instrument, to give the trustee the roadmap. But here's the problem with trustees, right? And I've been a trustee, I am a trustee, I know the problem. Practically speaking, the trustee is going to say, well, what's expected of me? What do I need to do? Like, how do I carry out my duty? How do I get from A to B? How do I do this and not run afoul of impartiality? And how do I do this and make sure that it's carried out in accordance with the statute? So I'm not going to get sued. So I'm not going to get my bank sued. Who holds the liability? Can I hire an agent to do it? Can I do this and still carry out the grantor's purpose if the grantor's purpose is really, I just want to save on taxes and I'm not really so interested in the ultimate outcome for my beneficiaries? Does the statutory language impose a mandatory obligation if it says shall? And what happens if the trustee has a beneficiary who's resistant to it? Is that now putting the trustee in a position where they're violating their fiduciary duty because the language is shall? So can this be something that sits properly with the trust protector so that the beneficiary has this provided to them through a trust protector and remove some of that obligation from the trustee proper? Can it be directed? Anytime there's something new, there's always lots of questions that come around. So I wanted to break down kind of what I see this developing the duty of care into. The duty of care, duty of prudence, duty of loyalty, all of those duties, we know them as trustees, but can we look at them a little bit differently in the light of this new statute in providing well-being for the trust, for the trust beneficiary? So prudence, competence, compliance, diligence. We also have to be loyal to the beneficiary, and not just in the sense of not self-deal. We need to actually care. We need to look at this through more than just an investment lens. We need to look at this through care with, as Jay Hughes says, care with a capital C. We need to feel interest and concern for our beneficiary. We need to give care to the beneficiary. We need to make maintenance actually enhancement, as opposed to just maintaining a lifestyle and saying, I need a budget, and if it's not in the budget, and give me the receipts because I need to justify this to my committee. Yeah, we all have that. That is something that is part of being a trustee in a corporation. But this can also be part of it too. This statute is the bridge between the fiduciary duty definition with the simple definition of care, of the Webster's definition of how to care for someone. So the beneficiary, they're on board. You want to go ahead and get this enhancement program, this beneficiary well-being program. And now the trustee looks and says, well, okay, how do I treat this? Is it a distribution or is it an expense? If it's a distribution, is there a tax consequence or is there a benefit? You know, if it's a distribution, there's a tax consequence to the beneficiary because now they're taking maybe that into income if there's some, you know, income that's being distributed. And how is that a benefit to the beneficiary if now they have to turn around and pay taxes on it? But it's a benefit to the trust because the trust is going to get a deduction for it. So we look at this in the sense of having to compare and always balance which beneficiary class enjoys the benefit. You know, is it just the current income beneficiaries? Are we going to make sure that the remainder class of beneficiaries are also subject to this enhancement and this well-being program at the different stages of life? If we do focus on the current beneficiaries, it's going to burden another class of beneficiaries that's not getting that because they haven't reached that stage of their life. You know, is it education under our HEM standard? Is it health under our HEM standard? Depending upon what that program is and how that program is carried out. You know, if it's an expense, it's going to indirectly benefit all classes of beneficiaries. If it's an expense and you have the authority, like in this statute, to expressly treat it as an expense, you know, is that governed by our fiduciary duties? Is that governed by the general management and administration of a trust, which is what the you know, common understanding and, you know, case law understanding is of what a trust expense is. So it looks like I can't control my own slides. There we go. So I've gone through and I've created basically a comparison between and a distinction between what a distribution is to a beneficiary and what an expense is to a beneficiary. And the way I look at it is that a distribution is a transfer of money to a beneficiary, transfer of assets to a beneficiary. An expense provides for the beneficiary in some way, or it provides for the maintenance and administration of the trust. So the purpose of a distribution goes directly to the beneficiary. It absolutely encourages well-being to the beneficiary because it puts them in a better position that they were in before the distribution happened. It satisfies a need that they have. An expense manages the administration of the trust on behalf of the beneficiary. So for the benefit of the beneficiary. Who's the recipient for distribution? The trust beneficiary. Typically, who is the recipient of an expense? The recipient of an expense is typically a third-party provider, a third-party service provider, a trustee, an investment management fee, a legal fee, an accounting fee, property maintenance, taxes. It's going to someone other than the beneficiary, which is why this is my solid, like, most important factor in why I think that this should be an expense of the trust as opposed to a distribution to the beneficiary, because these programs, these age-appropriate well-being programs that you can avail yourself to now and use the trust fund assets to pay for, they're not being paid to the beneficiary. They're being paid to a third-party service provider. And that third-party service provider could be an internal program that's been created through the trust company. It could be an external program. It can be a variety of programs, but the money is not going to be received by the beneficiary, which is what I think is the most distinguishing factor. You're going to be authorized by the governing instrument. With a distribution, you are carrying out as a fiduciary grantor's intent. You have to. You have no other choice. With an expense, You have a fiduciary duty to pay that expense or an operational need to pay that expense. And I think that as the fiduciary duty, because we have these two statutes now, that this is a power of the beneficiary, or excuse me, of the trustee, if it's written into the trust, we have this fiduciary duty to carry out that power. And the duty is to care for our beneficiaries, to actually enhance their lives. And when you look at the impact and compare the impact between a distribution and an expense, we see that distributions reduce the assets available to the beneficiary long term, because many times distributions, they do have an income component, but many times it's principal. With the impact on an expense, it does reduce assets available for future distributions, but you're carrying out some kind of need in order to administer the trust. So there's a potential tax benefit to the trust for an expense. It could be tax neutral. It is tax neutral for the beneficiary. So that benefits the beneficiary, and it could be a tax burden to the beneficiary if it is a distribution, especially if it's income, obviously. So when we look at a lot of the statutory enumeration, and I think Todd did an incredible job, and the Trust Act Committee did an incredible job enumerating exactly what this could look like, so that it gives trustees a roadmap and guidance on how to actually administer this. But there's some things that, when I drilled down, are open to interpretation. So a seminar, it could absolutely be considered education. You know, what else is a seminar? It's education. Courses, they're education. But a financial well-being program, it's very much open to interpretation. Workshops, open to interpretation. Personal coaches, short-term university programs, that's education. And there's a lot of different ways to spin the benefit of that, you know, as an education expense paid directly to the university program. That's going to be net neutral for the beneficiary and still provide a benefit to the trust. And as you look through these, things like family meetings, family retreats, family reunions, consultations, all of those different types of life experiences and life events on Todd's chart are squarely going to be affecting not just the one family member. You know, you can't extrapolate a family member from the family ecosystem and the family dynamics. So I think that those are very much open to interpretation. And this is what trustees are going to be struggling with and trying to figure out exactly how to apply this when they go to administer and implement the statute. From the perspective of the type of programs that can be provided in the statutory enumeration, we're preparing beneficiaries for inherited wealth. That could be interpreted, I just made up a new word, interpreted as education, but it could also possibly be legal advice, which would be an expense. Estate planning, that fits squarely into legal advice, because you're not going to get, you know, estate planning advice and asset planning advice from somebody who is not a lawyer or an accountant or a financial planner, a CFP. Intergenerational asset transfers, you're going to have the expertise of a lawyer to be able to explain that to beneficiaries. So even though it is academic and, in a sense, educational in a sense, it could also very much be squarely in the legal advice category. Money skills, I think if you're paying these to this third-party service provider, you really have a great argument that this is an expense of the trust. Financial literacy and acumen, there's also a great argument that it could be an educational expense. And if it's beneficial to the trustee or the trust or the beneficiary to treat it as a distribution, I think you have flexibility here based upon the facts and circumstances with regard to the trust that you're administering at the time. So it looks like I have run out of slides and I'm going to now share stop sharing my screen and float this back over to Lori and Rod to see if there's any questions from the group.
I don't know if there is questions from the group. I have to tell you, I was talking to, he had just retired, just so you'll like that, and he didn't ever go to your class. But when he read the thing, he just went, I invest money and I write checks, and that's all I want to do. And I said, well, it's a good thing you're retired. Because that's not all, that's here. But that was his mentality, and that's not unique.
It's not. And unfortunately, that kind of philosophy, that kind of mentality, it doesn't exist in a vacuum. And I'm a mom, I'm a parent, and I know what it's like to have your kids around and you think they're not listening, you think they're not watching, but they see and they hear everything. And
Right.
that's human nature. That's not unique to my family. And just because you have wealth doesn't mean that your kids don't see and hear and extrapolate that feeling of that mentality. The fiduciary doesn't have a choice. The fiduciary acts for and on the beneficiary of, or on for the benefit of the beneficiary. When I describe in class what a fiduciary is, my words are exactly this. A fiduciary has the obligation to act solely and only in the best interest of the beneficiary. You don't get a choice. You have to act for that person, and you have to carry out grantor's intent while you're doing it. So it's not an easy job, but statutes like the one that Todd has developed really give the trustee that it gives them the path to be able to start to implement what they should be doing anyway from an emotional, a mental, a physical well-being perspective.
Right.
Jennifer, there's one question, or so far that I've seen, the slides. You guys gave us the slides. Are you okay with us distributing them as a PDF?
Perfectly fine with me.
Todd?
Yeah, that's fine with me.
Okay. And then my follow-up question is, I'm all about, equal, fair, all of that kind of stuff. The questions that come from beneficiaries. Am I being treated equal? Is there a certain allotment that I get for me versus the whole family versus my sister? How does that come into play?
So I'll give you my, 30,000 foot answer really from an academic perspective. When I teach that fiduciary duty of impartiality, I make it very, very clear that impartiality does not mean equality. It means equitably. It means fairly. And there are procedural and substantive tests. Communication is super important, but it doesn't change human nature. That if my sister's getting a distribution and I know my sister's getting a distribution, why am I not getting a distribution? I want mine too. And that's something that trustees really have to balance. And the more education and the more communication and the more engagement you have with the family and with the beneficiary class, I think the easier it becomes for a trustee to explain that it's equitable and not equal. But from a technical perspective, in how you carry that out and how this statute carries through and really facilitates that, I'm gonna lob that right over to Todd.
You wrote it.
Yeah, no, I agree with everything that you said. Impartiality, it's all seen through the lens of the fiduciary duties, and impartiality doesn't mean equality, but I think it's sort of a needs-based thing, and requires an extra level of communication with the beneficiaries to understand, when those needs arise and what stages of life they're at, things like that. There was one other question. We only have a minute left, but whether there was, from an ethical or legal perspective, the trustee or trust company could provide services like family meetings. In my experience, and it's usually reserved for like the large clients that are the valuable clients to the organization, but this does happen, all the time. I work with some lawyers and families where there are individual trustees who host annual fiduciary sort of family meetings
Right.
at a location. And I know of large corporate fiduciaries that do the same thing. Jennifer, I don't know if you have anything to add to that, but I feel like that's happening already. And the idea here is to remove some of the impediments for why that's not happening more often than just for the most valuable clients that you want to retain, because it's sort of in your own best interest to provide those things.
I agree with you 100%. It should be happening. If it's not happening, it should be at least annually. In my experience, when I was at JP Morgan, we would try at least quarterly to see our families, to see our beneficiaries. You got to see the property. If you're safeguarding property, you have to check on it.
Yeah.
And your beneficiaries they're more important than property. So you got to be checking on them, and family dynamics they're really what makes this job interesting. It's fascinating. It's human nature. I think you have to make it a priority.
Well, we're at the top of the hour. I really want to thank both of you guys, and there's going to be lots of questions and things that come out of this, and the slides, particularly the one that you put up, Todd, with the life events and things like that. I think that's going to really help, as people look at this, because this isn't going to go away. I mean, this is something that's going to explode. And like I said, we have it in Delaware now. It's going to be everywhere else, and it doesn't have to be in a trust. I mean, I've people that have family banks that are literally like an LLC that have some of this language in it. And so having people understand this is where we like, I love that you're standing up, Jennifer, and saying, this is what it should be. I mean, and this is where it should be. And it always has been where it should be. But now it's codified, so
Yep.
there's no question about it. So Lori, you want to?
Right. Well, thank you both again, and thanks everyone for attending the webinar. We are happy to be able to provide awesome guests like this for our Expand Your Practice. So thank you both.
Thank you very much.
Thank you.